how to be ready when the priority date is back current for you. My name is Sam Shihab.
I'm Brian Burke.
And we're from the law firm of Sam Shihab and Associates. And we're going to be talking about this topic of, I know the priority date is retrogressed, and we're confident and hopeful that the priority date will move forward. What to do now that will put you in a position to move your case forward in an expeditious way when we return. So I'm told I must share with everybody that the material we provide today is informational only, and no attorney-client relationship is established, and you must always consult with a competent immigration lawyer before you make a decision on your immigration case. Having said that, welcome everybody to our Monday 6 o'clock 1 hour together. We do that every week. We are an immigration law firm in Columbus, Ohio, that practices immigration law nationwide and worldwide, and we focus on employment-based immigration law. And happy to spend an hour with you every week to answer questions and discuss a pressing issue the community is discussing. So today we're going to talk about priority date becoming current. What can I do now since it's retrogressed? What can I do now, and how can I get ready for the hopefully soon priority date becoming current?
Yeah, so as we sort of laid this out, Sam, there's basically sort of two categories of people. There are people with pending I-485s and people who haven't gotten the opportunity to file yet, people who are just really hoping the priority dates move in their favor so they can file a case.
Hopeful people and angry people.
Yeah.
Rightfully so.
Yeah, and we'll talk about, there's a good conversation we're going to have on that subject as well, about people who have the cases still pending. So let's start with the people who are hoping the priority date is going to move forward in their favor, have not been able to file their I-485 as of yet. Okay. So, just sort of a refresher for everybody. If you have an I-140 approved with a, priority date that's soon, all you need when that I-140 priority date comes up is that have an employer that's willing to give you a Supplement J. A Supplement J is the form that's required with Form I-485, and it's your employer's way of saying, hey, remember this I-140 that we got approved? Well, we're confirming for you, government, that we're still supporting that I-140, so thereby you should let this nice person file an adjustment of status I-485 based upon it. That's what Supplement J is really all about. So the $1,000 question, Sam, and the many $1,000 question really is changing jobs right now. What does the landscape look like for that, for somebody who has an approved I-140 at the priority date that's coming up?
Well, that's an excellent question. So I think, to me, I begin with where is your priority date based on the projected or expected, reasonably projected or expected priority date becoming current in the next, let's say, a year to a year and a half. Yeah. If your priority date is 2017 and beyond, or 2016 and beyond, there's time. Yeah. If you haven't filed your adjustment yet, which you wouldn't be if the person is from India. If you are from other countries, you're not from India, probably you have filed your adjustment status and you're attached to the country. But for people,
Sam, I'm thinking we're having a audio problem here because I'm
1, 2, 3.
1, 2, 3.
All right, so I think maybe the audio problem is better now?
It says we cannot hear Sam, and that means if you guys all get the joy of hearing me, hey, now it's good. We fixed it.
All right, perfect. Sounds good.
So Sam, we all heard me talking. Let's for a second.
Yes. So let's start from the beginning here real quickly. Exactly. Well, sorry about that, guys. We're talking about how to be ready for your case when the priority date becomes current. Yeah, we really haven't spent a whole lot of time talking about things. We're going to dive on people with I-140
approved.
Yes.
Yeah. basically, but your priority date hasn't become current yet because you're just, waiting.
Yes.
And basically, when it comes time, when your priority date comes up, you just have to have an employer through which you have an approved I-140 willing to sign off on a Supplement J for you. A Supplement J is a USCIS form that says, hey, remember that I-140 you got approved? We're still supporting that. We're still offering that job. So please let Mr. and Mrs. So-and-so file an I-45 based upon that I-140.
Did you set me up with the microphone? Did you turn my microphone, Brian, off?
I don't know, Sam. My microphone was turned on. That's for sure.
All right, sounds good. So, for those who have a priority date that is coming up soon, based on your country of birth, if you are, for example, from all other countries, obviously,
yeah,
it's moving. You're current.
Yeah.
If you are born in India, or chargeable to India,
yeah,
then you got to look at your priority date for your case and what should be coming, and then make some personal decisions.
Yeah.
Realistically, anything beyond 2016 is not going to happen soon.
Yeah, I would agree with that.
Okay. Sorry for those with a 2016 and beyond priority date. And those have, I think, plenty of options to move around, to change employment on H-1Bs,
yeah,
and seek to improve themselves or position, more stable employment, higher paying job, whatever.
Yeah.
And be able to have plenty of time to file your perm and your I-140.
Yeah. Because, if you're changing who you want to be your green card sponsor, the bottom line is you need to do if you haven't filed your I-45 yet, you need to do a new perm and a new I-140. And based upon the processing times right now, which are atrocious, they are what they are, but they're upsetting to people. It's about 7 months to get a prevailing wage, and another 7 months to get the labor certification approved by the Department of Labor after they filed. They're doing their best they can, I know this, but it's rough on people who are dependent upon the Department of Labor to move fast to basically extend their H-1B case or change employers, and get through that green card process again timely.
If your priority date is 2018 and you're chargeable to India, would you change jobs right now?
If your I-45 is not filed yet, that's a serious concern, because it's probably going to take you, a year and a half to 2 years to get through the perm and I-140 process. And obviously we're still optimistic that we're going to see some final action date movement forward during this year, hoping that we're going to see it go back to December 2014, where it is right now in December,
beyond.
And a little bit beyond. But you don't want to basically not be able to file your green card because you don't.
I wouldn't change jobs.
Yeah. Well, thinking about it, perhaps there's more nuance to it than that. Because, there's no requirement that you currently be employed with a company that is your I-140 sponsor. So it is possible to be working for somebody else, and if your priority date comes up, to pick up the phone and call your prior employer and say, hello, my priority date has become current. If you'd still like to have me, I would love to file for my green card, and I would be happy to come back to you if you guys are willing to support my green card.
Mm-hmm. Excellent point.
Yeah.
Okay.
I guess the point is don't burn bridges,
What about priority date? Same thing probably for 2014.
2014.
Same answer almost.
Yeah, again, as of this month still, final action December 1st, 2014 is current. And we believe, based upon maybe I'll reiterate it, but USCIS in their inventory right now, they expect to have an EB2 36, we're really talking about EB2, we have to mention EB3, what kind of movement we're talking there. But for EB2 folks, USCIS at the end of the fiscal year, they expect to have an inventory of about 36,000 unapproved Indy EB2 cases, whereas the allocation for this year was 60,000 green cards. If you assume a similar allocation for the next year, that should be enough to get rid of that entire backlog during this coming fiscal year and
more.
Logically move it forward. Yeah.
Yes.
So anybody in 2012, 2013, 2014, which it's hard to advise somebody, to move most employers understand this, because I'll tell you a story, Sam. One of our corporate clients said, Brian, we want to talk, bring our employee on with you to talk about, is it feasible to join, our company right now? And I said, well, sure, happy to do it. And, I just, know going into this that the advice might not be favorable, because ultimately I'm help our corporate clients to get people on board they want, but ultimately they don't want to make their new employee unhappy by leaving them in a spot where they won't be able to file a green card. So these are conversations we have with people.
Most employers won't.
Yeah.
I mean, if it's not win-win, it doesn't work.
Exactly. Yeah.
So shall we switch to if you have a pending adjustment of status?
A pending adjustment of status. Yeah. So
those who have a pending adjustment status, again, the first consideration is how to prepare, is to honestly, the thing that you and I were talking about is how many last minute calls we get.
Yeah.
And all the problems comes out in the last week.
Yeah, well, it's interview, folks. Not everybody gets an interview for their I-45 case, and everybody thinks my case is going to be the guy who doesn't get an interview. But when you get an interview, suddenly, your brain wheels start turning, and you think of every,
nuance of your life, every minute of your life about whether or not there's an issue.
I talk to people, I've been in the United States for the past, almost 20 years at this point. Maybe a little bit, 15 years at this point, and they start asking questions about every time there was a change of employer, every time there was an immigration filing, every little thing that went wrong. And when people come to us and they say, a week before the interview, they say, oh, what about this time, or I didn't maintain my status?
See, and that's where the problem is for a lot of people. So we in our office, and I'm sure other attorneys, similar situation, we have two types of adjustment review. One is a basic one. One is more intense. And the intense one deals with trying to find out things you think is not a problem, but it is a problem because you don't know. Like, for example, I was on leave, paid leave, or unpaid leave for 9 months. It was approved unpaid leave by the company, but it doesn't matter if it's approved by the company. But you think it is okay because it's approved and maybe you had a baby or something and you stayed at home. That's unacceptable. It could potentially cause an issue for your immigration case.
Yeah.
So you might want to have a review of your case. If your case is old, if you are not sure about certain things, or you're not the kind of person who's highly technical about immigration law, maybe maybe reviewing it now.
Yeah, I mean, think about these things maybe before the interview notice comes in. Now, granted, USCIS, they give interview notices about 6 weeks out, right? 6 weeks out is a lot of space, but bottom line is, so you can get a lot done in 6 weeks.
6 weeks out is a lot of space to get 90% of the problems resolved.
This is true.
Not 100%.
This is true. Yeah.
But if you believe that in somewhere you're foggy about an area, this is the time to resolve it, to prepare yourself for a smooth case. Something you're not clear about, something you concluded, but you just basically made a mental leap. It's challenging because sometimes you don't know.
Yeah, and here's the thing that sort of I need to point out. Just because USCIS keeps approving cases for you, it doesn't mean you don't have a problem necessarily, or there's there's no issue that they can bring up. Because, that's why INA 245K is there. INA 245K, if people aren't aware, is a rule that excuses up to 180 days of immigration oops, more or less, since you last entered the country. And that law acknowledges that, you may have, we may discover in processing your green card application periods of unauthorized employment, not having an I-94, or just otherwise not being in compliance with your status. And we'll forgive some of those. It's sort of built into the law that there's going to be some issues out there, and those are the sort of things, if you know about them, if you talk about these things first, you'll know whether you have anything to worry about.
It's nice to have one answer whether or not you have any status violation day by day, and it's nice to know that they're less than 180 days.
Yeah.
To a full precision, right?
Yeah.
And it's nice to also know that even assuming those gray areas are not resolved favorably, you're still under 180 days.
Yeah.
And it's also a good idea to know if you're over 180 days now, and how you can fix them.
Yeah.
These are the opportunities you can have before you walk into an interview. I mean, we're dealing with a situation where people say, oh my God, I've had the worst interview in the world. When I walked in, and this doesn't happen every day, I can't believe they pulled this thing that happened 14 years ago at the consulate.
Yeah.
And I just can't believe, and I was young and I wasn't really careful and I wasn't really, you know, and it's like, what happened? Well, you didn't tell us this. Wow, let's go over it. And we feel that maybe we could have resolved this. Yeah. So, and then you get people can't sleep at night. So proactively address your issues.
Yeah.
Everything we talk here with an attorney, your counsel, and for my clients, everything we do as lawyers is attorney-client privileged. It's confidential. Just you need to come in and say, I fear 1, 2, 3, 4, 5, and we can go through them and check them.
Yeah.
And that can make a huge difference in your case preparation.
Yeah.
Medical examination.
Yeah. So okay, we hit the heavy one first. The existential threat, easy one. Medical exams. They last 2 years right now. You guys, especially those who filed way back in October 2020, your medical exams are about to expire. There you go. If you're not, you know whether or not you're current in the month of October. If your medical exams are soon to expire or have expired, get new medical exams. They're going to want them.
Do you interfile that, or you get them ready?
The FAQ, I believe, still says they don't. I believe it still says they don't want them. Somebody can correct me if I'm wrong if they've updated in the last couple of days. So there you go. And they're still issuing RFEs, seeking medical exams, and there you go.
Okay. At least you're aware it's needed, and as the priority date becomes current, you just take care of it.
Yeah, I mean, most, back in October 2020, it was very hard to get a medical exam for immigration purposes because there was huge demand. It's a little bit easier right now. But you always want to get your RFE response in as soon as possible because you want the green card in your hand as soon as possible, and they need that, remove all obstacles as fast as they can so they can improve the case,
Birth certificate is another issue that we see sometime. It's kind of funny because when you tell somebody, I need your non-availability certificate, and you get this answer, it's impossible to get, it's very difficult to get. But when you get an RFE with 30 days that we need it, they can get it right away. Surprise. So if you have a defective birth certificate documentation, fix it now. Don't wait for the RFE. You're going to get the RFE, guaranteed. The rules are very simple. The birth certificate has to be issued very close to the date of your birth. It has to have your name on it. You have to have your parents' name on it. It has to be issued by the county or the province in which you were.
Yeah, the local authority is responsible for managing these things in whatever country you're from. So yeah. Your name, parents' names, place of birth, date of birth, registration code. Yep. That was me running through my checklist.
Yep. Yeah. And you just have them ready. And if it's defective, fix it. Affidavits, secondary evidence. Go get the secondary evidence now. Don't go rush the last minute. You go into the family archive, get your old grades, old medical documents, old vaccination record that has your parents' name, your address, where you live, and just pile them up. Hand them to the government. Let them enjoy themselves looking at your history with your name on it, your mom's name, your dad's name, and get that resolved. Now, Brian, what do you think we need to talk about now with regards to preparation?
Well, the kind of elephant in the room of this is a bunch of baloney. I shouldn't be having to prepare for my I-45 priority date to become current because it was current. It still is current for many people because it's still September, but we all know that USCIS or the Department of State has, issued all of their employment-based green cards for the year. And we know that, the retrogression for October is there. And it's an M word, Sam. It's mandamus actions. It's is this finally the point where you say I should be?
Is this the time to get ready to file the lawsuit when my priority date is current?
Yeah. And what's the standard for whether or not a court will force the government to act on your case, Sam?
Well, it's the one that nobody understands what it means, which is reasonable period of time.
Yeah.
The government has a reasonable period of time to adjudicate your adjustment of status application, and the reasonable period of time, in our opinion, has clearly been exceeded by wasting 65,000 green cards 2 years ago, approving cases before other people this year, and then retrogressing everybody and sitting on the priority date now.
Yeah. I think in terms of
shutting it down.
like writing a narrative, writing a story. So I filed my adjustment of status in October 2020. If I was waited a long time, awesome. And then my date was current for most of that year, and then they wasted my date. Even if my date didn't make it current, they wasted 60,000 visas. And then the next year, my date was current, the whole year, and they didn't approve it. But they approved my buddy over here who's had a date a year ahead of me, and yeah, it's it's.
And then when it opens again, the difficult the reason I cannot, when people are contacting us and asking me, are you ready to file a mandamus when the priority becomes current? And we always tell them, of course. We're lawyers and that's what we do, is practice law. And they say, can I file my mandamus the week the case is current? I want to get my case ready now. I want to draft it now. I want to file my mandamus the week I'm current. What would you tell these people?
I don't think that's that's the. It's a tough one.
It's a tough one.
Part of me says, that you've been waiting for 2 years, but we've seen from last year, a bunch of court cases get basically snuffed out by courts because the government says they're out of visas. We can't approve these cases because visas aren't available. And now, visas just became available.
And for how long are they going to become available before they retrogress again?
That's the problem. I mean, you want to say wait a little bit of time, give them some time, because we do believe that they're going to try to clearing out that backlog over this year, and we believe the dates have to move forward for everything we've seen. But how long is too long? Eventually, I guess, maybe see where the next visa bulletin goes, maybe see how the first quarter goes.
When the government is approving cases in a random way, and in a complete disregard to the law. And do you have that law?
I do have that law up here, and here's what it is. So this is 8 U.S.C. 1153 F1, and it basically under the heading Order of Consideration. Immigrant visas made available under section A or B shall be issued to eligible immigrants in the order in which a petition on behalf of each immigrant is filed. Yeah.
So if it's in the order, in the order in which it was filed, so clearly by the priority date.
Yeah.
In other words,
that's the way it is perpetually interpreted. And the bottom line is, Sam, is we know that's not exactly how things have gone, because
it's unbelievable.
Anybody in our audience, and they'll know somebody who has if they don't have their green card yet, they know somebody who has a date ahead of them and got their green card.
So how can you tell somebody, no, I'm not going to file your case, when you really don't know how long that priority date window is going to be available before they shift it back again, or the government, and that the government has approved cases many months after this guy's case or this gal's case last year, without any regard to the law. Now, I know it is very difficult to keep it strictly within the priority date order when you open up 50 offices to process.
Yeah, we were discussing this. You can't hold up, 10,000 cases because one guy has a difficult case that USCIS hasn't approved. It's really hard to hold very 100% true to approving these things in the order in
but
which
you can open up, let's say, cases for 6 months. Let's say we're going to open up 2012, January to June, and then let's open June to December. So you can create a block of priority date and then say, we're going to try to approve as many of those as possible and move on. There was no system of priority that we're aware of that the government has followed last year. I'm going
to give them a little bit. Sam, they did what we thought at the beginning of the year was impossible. They did get out, 281,000 green cards, but tell that to the other 36,000 people.
And
with
for those who
pending
got their
cases.
green cards ahead of others, congratulations to you guys. I mean, we are not unhappy for you. We are very happy for you.
Yeah.
And if I get my green card ahead of the other person, I would say I'm very sorry, but I'm very happy for myself.
Yeah.
It's
Yeah. This is a healthy attitude. There are people. I have people out there. I just talked to somebody, late last week. I retrogressed, and I had this conversation with them. I said, big picture, even though you didn't get your green card yet and somebody else did, every person who gets a green card in front of you is one less person in line in front of you. But
it is what it is.
Yeah,
it is what it is. Yes, high five for the government approving all the green card cases. High five for those who got their green cards. And for those who did not get their green card and got passed over because the government is chaotic, they broke the law.
Yeah.
And that's the fact. That as I interpret it, I mean, I don't see there has been any system of prioritization except that anybody who has a case that we can approve, we will approve it in the most random way possible because we really were just not prepared to handle the volume.
Yeah. Again, maybe you can't really hold it to all the January 1st, 2013s get approved. Then we approve all the January. Maybe you can't hold them directly to that, but when it comes time, I think about, Sam, we've been talking about mandamus actions for like a year and a half now at least.
Yeah.
I think about, if I'm not going to try to tell a story to a judge, that's what I started thinking about. Fooled them once, but the government wasted 60,000 green cards, and the next year they were current and they didn't, and theirs wasn't gotten to, and now it's just it's an interesting it's something I would weave into the narrative for that.
And mandamus action against the government is not new. Mandamus action against the government is very old. I filed mandamus actions as far as 20 years ago against the government, and there is very little downside, or any downside to filing a mandamus action. Really, very little. The government does not retaliate. I have never seen a single case in my career in which there has been anything negative.
I would love to be on the side of a case where it's clear there's government retaliation because if you go after the government on that, the government will.
It's huge.
Yeah.
There's never been, and not every case, but many cases get resolved quicker.
Yeah.
True. I mean, many cases get resolved quicker. Not every case. So there is really no downside to mandamus. Really, it's the only downside is you're paying a little bit of money to trying to maybe put yourself in a position to help your case.
I mean, the challenge is, the problem. I'll be Mr. Other Side of the coin. Is the problem is people tried this, last year, and they. So it's not I guess it's definitely not a guaranteed result. We know that a lot of mandamus actions were filed in
Well, a lot of mandamus is filed because the attorneys, as we've always done, we've told people you got to wait a little bit. You got to show the judge that you've waited and you passed your processing time, and now you're behind processing time for the judge to give you a reasonable consideration. What we didn't know is the government is going to pull the plug and retrogress this thing 2.5 years.
Yeah. Again, I think add time to your mandamus case, and you always have a better one. The one more day you wait every time. So
what happens if they sue? What to expect?
Like you said, a lot of cases, on every side, if you sue the government, on your side you have a private attorney that it is their job to sue the government. Great. And on the other side, there's a government attorney. And that government attorney, they are human beings, and they get a court case sometimes and say, this is not worth my time. And they can pick up the phone and tell, USCIS and say, make this court case go away, render it moot by acting on this case. That's not a guarantee, though.
It's not a guarantee, and less likely now than, let's say, 5 years ago. Just because of the sheer number of cases that the government is facing now, they're saying we just really cannot.
Yeah.
We have to fight it back. It happens all the time. We have to fight back because we just need to slow it down.
Yeah.
And the only way, so there's going to be pushback, and we've seen pushback.
Yeah.
But it doesn't matter, pushback or not pushback, you're entitled to your adjustment, and then a reasonable time has passed, and nobody wants to be in front of the judge.
Fundamentally, it's if the GIST guy doesn't want to have your case adjudicated, then suddenly it's a competition of who can improve. Is it show the judge that the government isn't reasonable at this point, and that's why I don't think they're reasonable at this point. 2 years to approve an I-485 case? That's ridiculous.
A judge wants to hear what this case, and you begin by telling, Your Honor, my client has been in this country on a work visa for 14 years. Now my client has 2 U.S. citizen children, owns a house, okay, and completely integrated in the U.S. society, and the government has been wasting green cards. 65,000 green cards wasted 2 years ago.
60,000?
60 or 65,000. Last year, they didn't follow the law by approving cases in the order in which they're filed, and approved many cases after my client's case. And now my client is desperate to get normalized.
It's finally current again.
And it's a situation where we are asking for fairness.
Yeah, it's finally current again. I understand giving them some time, but it's finally current again, and I don't know how long it's going to stay current.
Yeah, my client is not asking for special treatment. My client is not asking for a break.
Asking for treatment.
Yeah, my client is asking for only what the law allows the client, to receive.
You can't just sit on a case.
And a judge, some judges don't care. And most judges do care, and they don't like to see a situation where people are not fairly treated. And it's fairness is what really this thing is all about.
Yeah.
Well, that's our discussion for today. We are going to take your questions in 1 minute when we come back. All right, so this is when we begin taking your questions. So for those who, we will take them in the order they're received. We try to follow the rules. Now, our system does not feed us information on questions posted before the streaming time. It's a glitch in our system. We apologize. So if you've posted something before the streaming began, we don't get to see it. So without further delay, let's start with the first.
Check out what we got.
Yeah.
So from Sky Limit, I like that. That name. Hi, Sam and Brian. If the spouse on H4 uses,
I'm sorry, Brian.
That's okay. If the spouse on H4 uses adjustment EAD of EB5, and I keep my H1B EB2, and in case she wants to go back to H4 after her current I-94 expires, can I-539 be filed for H4 extension? So what it sounds like to me here, Sam, is somebody with a pending adjustment has used the associated adjustment EAD and wants to get back on into status. And it doesn't sound like that's a viable scenario by filing an I-539. Well, so the general rule is that if you want to extend your status, you have to be in status, and basically using that adjustment EAD puts you out of status. I would say, Sam, it wouldn't surprise me if USCIS would approve that case, because there's what they say their published policy is and what they're actually willing to approve. There's sort of a quagmire of unknowns in there, but generally speaking, I wouldn't count on that. I would presume travel to get back.
So
on
what makes this case more difficult is the I-94 expired. So there's really, you cannot go leave in the country. You just, there's no automatic revalidation on the table, so you cannot do that. So you just have to leave the country and re-enter.
Yeah.
Now, the husband is on a. Now, here's one thing. So I'm not going to rule out the automatic revalidation, Brian, on this one.
Well, yes, that falls in the quagmire of things where their policies aren't clear, and sometimes they surprise me by what they do.
So the regulations on that, it says if they had if they have an expired H4 stamp or any other stamp, the regulations on that, or it says that it could deems it can extend it.
Yeah, but I think in the automatic visa validation, there's a requirement of maintenance of non-immigrant status, though. But again, that's open for interpretation.
Yeah,
What
you
is
have to
it?
have
What
a
is
valid
that?
I-797 or valid I-94.
Yeah, but again,
Yes.
they do things that sometimes surprise me.
I would say less likely
But
so.
SkyLimit has some follow-up, maybe some clarification. In case she uses her EAD, can she return back to H4 if she goes out of the country? Yes, most certainly.
Well, if her H4 expires, she can go back to the border and come on H4 again, showing documents she is a Canadian citizen.
Oh,
Well, okay. So thanks for throwing the Canadian citizen piece there, because obviously at the border they're easier, but still she does not have an H4 visa stamp valid.
but as a Canadian citizen, they should not. I don't, as I recall, Canadians don't require visa stamps even for H1, H4. So meaning she should be able to go back to the border with, So I guess SkyLimit here has a really unique scenario.
Now, my question is obviously, does she have an advanced parole? Because it's important not to leave the country if there's an adjustment pending without a valid advanced parole.
Well, yeah, but if she's a Canadian citizen though, they should admit her without a visa stamp, right?
Right, but she left the country. So when she if she does not have a valid advanced parole, then the adjustment is abandoned, even if she's Canadian.
All right.
Yeah. So interesting question. So let's take the next one.
Yeah. So, one of these great ones. Manoj Kumar, priority date September 2015. Any chances for EAD? Just getting to filing dates. And September 2015, which would be about all 9 months, 10 months beyond where the final action dates have been made. I think it's possible.
I'm sticking to 6 months.
Yeah. Well, but he's talking about filing dates. I don't know. It's
An excellent point, Brian. Excellent
Yeah.
point. So, priority date 2000, any chance for EAD, just filing date? Yeah, I think so.
So this is what I usually. It's tough.
Still,
It's
it's
tough.
a tough one.
You would not, Manoj, you could call me on, in August 2015, and say, Brian, my priority date, my filing date's current for September, and my brain wouldn't be blown open. I wouldn't be, betting the whole house on it.
Yeah, I agree.
There's those nice folks who, those nice comments who let us know that Sam's mic was not there. We are watching the chat from the very beginning, so thank you guys very much for pointing it out. There we are.
Thank you, guys.
Yes.
Triple A.
I think that's more than a triple, Sam. I think it's a Google of A's.
Triple A's.
Yeah, it's triple. Yeah.
My priority date is February 2015. India. Do you think I will get opportunity to file for this fiscal year? We truly believe so.
Yeah, I mean,
we really believe so.
We'll reiterate it. USCIS said for EB2 that they have 36,000 cases in their hand. There's an estimate at the end of this year. If this year's allocation for EB2 India was 60,000 visas, if you get something similar, you will make it through that backlog of 36,000, and after you do that, you have to move the dates forward so you can take new cases, so you can issue those visas.
Yeah, we really think that the rest of the world green card adjustment this year will be lower for two reasons. They've cleared the warehouses last year, evidenced by the fact that they moved India in the fourth quarter. They wouldn't move India, EB2, in the fourth quarter unless they ran out of the rest of the world adjustments to make. That coupled with pandemic slowdown of I-140 for the rest of the world gives lower rest of the world expected green card equals more EB2 India.
Yeah, there is a lower overall visa allocation for the coming fiscal year, but even that being said,
that offsets so it gives us the same.
I don't think it's crazy to say you get about the same allocation this year as you did.
We really think so, yeah.
Yeah.
All right,
we'll wait and see. So, Harsha Vardhan Bhatt. See, this is, EB3 AOS filed in October 2020 and received EAD AP combo card for 2 years. 2022, April, applied for second AOS and EB2 and received only EAD card. I'm planning on travel in November 2022.
So this is a question we get all the time.
Yeah, I think
is worried about.
Am I tied to one case essentially if I use the advanced parole?
Yeah.
Yeah. So, USCIS does not have a 100% clear policy on this, but I've never heard of it being questioned, essentially.
When you leave on advanced parole, that's a permission to leave the country in advance, and it's not an abandonment of your adjustment of status. You don't have to have 2 advanced paroles.
Yeah, I would like to see them try to.
I've never seen a single case in which that's been an
and
issue.
multiple adjustments, is not a thing that's just invented in the last couple of years,
And recently, USC has been doing something funny on EADs at least, which is they're denying a second EAD because the first one is approved. Haven't seen that on advanced paroles, but you don't have to have an advanced. Otherwise, if you have 2 advanced paroles and approved, and then you leave the country, you're happy, you have them, then you enter on one, it doesn't affect the other, so it doesn't matter. I think you're good.
Yeah. Let me see here. So I think there was a follow-up from Harsha Vadhan, and this is about,
All right.
Yeah. Can I still use exactly the question?
Yes.
The question you used, you presumed the end of it correctly.
Yeah.
So hello, Sam. Sam, I think this one's for you.
All right. Hello, Sam. One of 2. I am one of those October 2022 filers downgraded from EB2 to EB3 in June of 2022. Filed transfer on a line basis, and both my EB2 and EB3 I-140s are approved. Wonderful. Congratulations thus far. My application moved to SRC, to another office, just today after almost 2 years. What does it mean? That's an excellent question. Let's go back and look at that priority.
Yeah, that's exactly where my brain was going, sir.
Yeah.
Here we are. Well, your priority...
don't have that.
Tabasum Fatima's priority date is not in there, but, so odds are...
So I'm assuming you're a 2012, maybe, priority date for that to move forward. Although I'm seeing people
whose priority dates aren't yet current
and moving
to the National Benefit Center. So let's talk about what
yes, let's do that. Do it.
The trend we've seen, and still the trend as far as we know, is that when USCIS moves your case to the National Benefit Center, they're not really moving it to the National Benefit Center. They acknowledged back in the beginning of this year that we have field office people who aren't working at full capacity. We are sending employment-based green cards that would normally be adjudicated in Texas or Nebraska. We're sending these out to local field offices so those officers can approve those cases. So odds are that that other office is the National Benefit Center, and that's where somebody might be able to approve your case. And
And I will be curious to know your priority date, because if obviously you're current, that means your case is moving forward.
Yeah.
If you're not current, and we've seen recent approvals, we still have a straggler adjustment approvals here and there, but those are the exception, not the rule.
Yeah, I want to elaborate that. They say they're out of green cards for this fiscal year ending in September 30th. We are still seeing stragglers come through. So part of how they allocate those is a bit of a mystery.
Whether somebody pulled a number and then didn't move on it and then went back to the file and say, there's a number here. Let's get this case out. They're not as organized as you think.
Yeah.
All right, let's take the next one. Yes. Hopefully we help the team out. Yes, Ven. Go ahead, Brian.
Priority date December 2013, my case and my spouse case got transferred from Texas Service Center. If there are no visas available, why USCIS transferred my case? Any idea what happens next? A good segue from that one to this one, because it's kind of on the same page. So historically, Sam, for me, this is basically sometimes they do things before dates are available. Historically, it was just before everything went crazy during COVID times. But we would know that whose priority date was going to become current in the next month when we would get an RFE for them. Sometimes saying, "Oh, we want your birth certificate, or your medical exam," something like that. That's what I kind of think about.
So December 2013, that's almost more than a year and a half move forward.
Yeah.
So it's good that they will surprise you with but it's going to have to be the second quarter, as we anticipate. We don't anticipate movement until the second quarter.
Yeah.
So there's there's a visa available for you, 1% chance of that, but it's not out of the question. 2, they're preparing your case for approval.
Yeah.
3, the right hand doesn't know what the left hand is doing.
It is not a waste of their time to get your case to a point where they can say, all right, we can approve this thing as soon as a visa becomes available to you.
I mean, remember, they have 200,000 green cards to approve this year.
That ain't a small number, yeah.
It's not an easy number, and they're just going to have to start mobilizing and move forward and pick it up early for that to happen.
Yeah, yeah.
So we'll see. All right.
From Sudipta Bhattacharjee. My EB2 party date November 2010 and RD October 2020 Texas. Receipt date, there we are. I-140 approved, medicals pending, case transferred to San Antonio field office in April 2022.
Okay.
Should I file individual litigation to expedite my case? Thanks. Wow, November 2010.
I would say yes.
Yeah, I mean,
I would say enough is enough. The glove is off. You need to get your case.
It's worth talking about. That's
you need to get your case approved.
Yeah.
Absolutely. I think if your priority date is current, and something like November 2010, for crying out loud, I wouldn't wait any longer.
Yeah. Well, I mean, it's somebody's personal choice. I mean, it's worth talking. I think it's worth having the conversation.
I mean, it's their personal choice, but we're being asked.
Yeah.
And we're being asked. We're giving you a general.
I think
opinion.
you have a compelling reason to tell them to move your case, and it's the sort of thing where if you file, they may just say, well,
cases are approved 4 years after this case is filed.
Yeah.
And this case is still not moving anywhere.
Yeah. It's pretty ridiculous.
Yeah. You want to review your case. You want to make sure that your case is solid, and file that mandamus in court, in my opinion.
Yeah, I mean, this case is unique in that this priority date is current now. I don't know the exact facts of your case, but I don't see any reason why it shouldn't be approved. Pending for 2 years, that's crazy.
Yeah.
Yeah.
Swati L. I have an adjustment status application in EB2 and in EB3. And all these duplications, Brian, that tells me everybody has a duplicate case anymore.
Yeah.
And that means that 45,000 to 60,000 number is probably 1/3 of it should be reduced, which means more green cards this year.
Yeah, exactly.
Yeah. I also started using adjustment status EAD in April. Also have my H4 valid until February 2023. What status am I currently in? My primary is still on H1B. How can I get back on H4? You are in a pending adjustment of status. You are in an authorized stay by the Attorney General. You are not on H4 status.
Yeah.
You are not in violation of the law, and this is 100% an acceptable status to be in now.
Yeah.
If you would like to get back on H4, obviously you understand that unless you have an H4 EAD, you will not be able to work under H4, because the moment you start working, you're out of H4 again.
That's the real thing, the real chicken and the egg scenario. People want to get back on H4 status, and then they file. Okay, so you come in the United States, and then you go to abroad, go for H4 stamping, come in the United States, and you want to work. And then we all know how long it takes for an H4 EAD right now. It's a tough spot. It's really kind of hard to get back on H4 once you've left it behind. That's, not hard to get back on H4, but getting working again due to the long processing times of the EAD. That's really the rough spot.
So there are two options that are obviously available to you. Is one, whether if you have a valid H4 stamp on your passport, there's a simple exit the country and come back, go to Mexico or come back, or to any country and return to the U.S. and present your husband's H1B status. I'm assuming your husband's on H1B.
Yeah, primary on H1B, yeah.
And that should get you back to H4 for the duration of your spouse's H1B. The second, obviously, the automatic revalidation of visa, which it would appear to me available to you, but on every automatic revalidation visa, I don't like to send people out of the country without having a check with your attorney to look at your document, look at your facts, lay it out for you and say, yeah, I'm confident you're under automatic revalidation visa.
Yeah.
Because while a lot of people go and come back without a problem, every once in a while, if it's not done perfectly correct, it can be an issue.
I think there might be a problem, and there might be a maintenance of status question. If you read the automatic visa validation policy, I believe it says that somewhere in there, and I don't think necessarily every customs person is going to be looking at your status.
So there's a matter of interpretation. I agree with you, Brian.
Yeah.
It's a matter of interpretation. So a very strict interpretation, no. But honestly, it's not being interpreted that way. To be very honest with you,
I hear some people have success, some people don't. Yeah.
Exactly. So you need to have it laid out by your attorney.
Yeah.
And like I said, it's all about the officer who's interviewing you at the moment. And you can have a perfect automatic revalidation and have issues. if you're armed with an advanced parole in your hand, you got nothing to lose.
That I fully agree with. It's
And
it's a low risk in Denver there. Yeah.
Yeah, absolutely.
So a question from VJ Singh here. Priority date is April 2013 EB2. When can I expect my GC? Any chance in fiscal year 2023?
I would say you have a pretty good chance. I'm assuming, did he say AB2?
Priority date is
AB2,
April,
yes.
Yeah.
So I would say pretty good chance this year.
Yeah.
Yeah.
I mean, you are about a year off from current right now, and
we think is going to cross that current, and then the question is when they're going to get to your case, and whether they're going to approve cases after you, and how you're going to be treated. So, I mean, that's the elephant in the room that we've talked about. And otherwise, in my opinion, if they're doing their job, you should get your green card this year.
yeah, I mean,
You should have gotten your green card last year.
yeah. So USCIS, they rolled back their visa bulletin, for EB2, 2.5
April
years.
2012.
2.5 years essentially.
940
days. They can't just cut off the stream of cases forever. They can't just say we're not going to take any new EB2 cases if they don't think they have the visas for it. But it seems like they're going to have visas that go on. They're going to need to take more cases, move the dates forward in order to approve people to clear out their backlog, and ultimately it seems like they're going to have to take new cases during this fiscal year.
I won't be surprised to see the filing date moving even as of next month
Yeah.
forward in preparation of moving the final action date.
Yeah.
All
Here we
right.
are.
All right, Brian, take that one.
Sure, from Mohan Raj, AG. My EB2 priority date is April 2016. Can I change jobs now? And what are your recommendations? So you were kind of right on the bubble there.
So obviously chargeable to India, I'm gonna have to assume.
yeah, I'm going to presume that. Yeah.
And April 2016 is not gonna be current this year.
I don't.
I doubt that it will be. I do not know for a fact. Nobody knows.
You wouldn't blow my mind if somebody told me on September 3rd, 2023, about a year from now, and they say they really opened up the filing dates for October or for September, and again, I guess it's kind of nobody has the answer for this one, Mohan. Nobody has the answer, right?
Well,
and basically, for me, it is a gamble on how long it's going to take to do the perm and I-140 process through a new employer.
So the perm is slow right now with the prevailing wage taking 6 months.
Yeah.
To get issued, which is I have absolutely no idea why it's taking 6 months, and then so it's taking you want to build in a year and a half span to get back on an I-140 ready to file I-485. So the question to me, will the visa bulletin likely to be current in a year and a half from now? That's the question.
Yeah, and that's a tough one. That's a tough one.
So that's really the question he's asking.
Yeah.
And it's on the bubble. It could be. Hard to predict.
Yeah, I don't. Do I super believe in April 2016? About a year and a half from now. That's a big long movement. That's for sure.
And the next question is, would my employer take me back if it moves quicker?
Yeah. I guess ultimately you want to be able to file your green card as soon as possible. And if if you've maintained a positive relationship with your prior employer, it's always possible to say, hey, my priority date's current. Would you guys be willing to take me back? Heck yeah. All right. Well, I'll see you guys in a week, and I'll be on board there. Yeah.
So those are the questions, and you need to answer those. I mean, the first one, I'd say it's a 50-50. I'd say less likely than it is likely.
Yeah.
I would say 40% it won't be current in a year and a half.
Yeah.
60% won't be current in a year and a half, in my opinion. But it's just my opinion.
Yeah.
All right, let's take the next one. All right, so Ravi Shamana. Will the 6K spillover completely come to India? Why won't USCIS move the date back in November? When they get the spillover? Why do they wait until June 2023? Well, good question. So will the spillover completely come to India? No. So the way it works is this. So you have 60,000 spillover added to the 140,000 numbers that we get every year. So that's 200,000. Mm-hmm. Then they're divided at 28.6% for EB1, EB2, and EB3. And then the remainder to EB4 and EB5. I believe it's 7% or 10%, I forget.
10%, I think, each one. Then China gets some of it, up to 7% of that 28.6%. India get the first cut, 7% of the 28.6%. And then they look to allocate for the rest of the world. EB1, if it's not used, it drops to EB2, flows across into EB2 India. So not all of it goes to India, but a lot of it goes to India, EB2, and then some of it goes to India, EB3.
Yeah, the bottom line is when the rest of the world does not use whatever the government has allocated at the same time, it will go to the highest, oldest category, which is EB2 India.
Yeah. So there's 10,000 green cards going to EB5. Take that out of the 200,000. There's 10,000 green cards going to EB4. Take that out of the 200. Now you're down to 180,000. Some will for sure go to China because China is backlogged. So you need to take about 7,000 green cards going to China.
Well, the China shouldn't get more than their 7% though, because
that's 7%. It's about 3,000.
Yeah. Okay. Oh, I see what you're saying. They're gonna. Yeah. So all the countries are going to take their share for the period before any spillover goes to India, but most other countries don't use as nearly what their allocation is, and that's when it starts going to India.
So 200,000, less 10,000 EB5, less 10,000 EB4, less 7,000 China. That gives you what, 170, 160,000, and then the rest of the world, and then the rest goes to EB2, EB3 India, with most of it going to EB2 India. The question is, what's the rest of the world?
Yeah.
And that's the $50,000 question.
Yeah, I'm going to put out this year's numbers. So basically, for this year, 281,000 visas, and USCIS estimated about 60,000 going to India EB2. So a lot of visas will go to India EB2 because that's just how the system kind of works. It's just not every bit of spillover goes to them.
Guru.
So my I-45 shows change in jurisdiction. Any idea how to find which center it's transferred to? So I'm going to presume that Guru's gotten a notice that says it's gone. Probably it says it's gone to it usually says on the notice where it's gone, but if it's, again, this National Benefit Center thing where basically we've found that these cases are not at the National Benefit Center, it actually means they're sending them out to field offices. So how do you get that answer? If you use the online tool, the online chat tool, Ask Emma from USCIS, that chatbot, actually you can eventually get to a live person that might be able to give you that information. Or if you call USCIS at the 1-800 number, oftentimes you can get them to admit where it really is.
Not all the time, but
yeah,
if you're nice enough for them and they're nice enough, they'll give you this information.
Sure.
All right, Venkat.
Yes.
Thanks, Sam and Brian, for taking the time. My question, if I was current and applied for 45 EAD advanced parole, then traveled on emergency and advanced parole gets denied, after I return to on my H-1B, I am no longer current, can I apply for advanced parole? So when you re-enter the United States, and let's assume you don't have an advanced parole, but you enter on H-1B, obviously, and then H-1B runs out. So when the H-1B runs out, you're authorized to stay in the U.S. You're not authorized to work in the U.S. And you can apply for advanced parole and get it, and apply for, well, you have an EAD, you can work, I guess. I should correct myself. The EAD is not denied. So you can continue working on EAD. It's just you cannot leave the country until you apply for a new advanced parole. And the answer to the question is yes, you can apply again for advanced parole.
Yeah, yeah.
I just had to analyze it in my head before
I
answer the
I
question.
completely understand that. You have to talk through it a couple of times. Or
should I wait to be current again?
Yeah, then follow up.
No.
Once your I-45 is pending, retrogression does nothing to you, aside from it tells you you're not getting a green card in the immediate future. You're still allowed to apply for those interim benefits.
Yes, absolutely.
Yeah.
And as many times as you want, and they shouldn't charge you a fee. In order to reduce the backlog, U.S. has announced in March 2022 that new cycle time goals for I-77 and I-131 would be 3 months, and I-45 would be 6 months. Does this come in effect starting October 2022? Well, underline, highlight goals.
Yeah.
You know, goals are not reality, but I welcome that. Let's see what they do. I know the Biden administration officially are looking for ways. Officially now, they want USCIS to find ways to approve the I-45 quicker. This was announced last week. Quicker I-485 processing and quicker green card approval and quicker H-1B approval. And they want them to look at their process to find ways. And the simple is very simple. Follow the law. Stop implementing a standard that's not in the law. Follow the preponderance of the evidence standard, which means if the case is 51% approvable, it should be approved. Right now, what they do is they look for the case to be 98% approvable. And anything less than 98%, they RFE the heck out of it, interview the heck out of it, okay, and waste everybody's time. The law says, more likely than not, if the case is more likely than not to be approved, you should approve it.
Yeah.
And go ahead and start approving these cases and let people move on with their life.
Yeah.
Next question.
What do we got? Well, it's a Sam question.
Early March 2015 EB2, I'm expecting to have at least dates for filing reach my priority date this year. What
about final action date? Yeah.
March 2015, my priority date. I'd say March 2015. Yeah, I think 15. We will reach December 2014. I'd say that's very realistic. For final action date.
I don't.
And beyond that, in my opinion.
Yeah, does this? I mean, that's a funny thing we've learned. Just because your final action date goes current doesn't mean you're necessarily going to get your green card this year.
This is a new one, right?
Yeah. But the bottom line is, this is actually what worries me, Sam. They're saying they retrogress so much, and they're saying, okay, I guess we're not taking new I-45s. If we believe, and I've said this before, if they have to move the visa bulletin forward to take cases, I wonder how they're going to get the cases timely enough in order to approve them during this fiscal year, assuming they're not just going to be approving the ones they have, the 36,000 India EB2s, and they have in their backlog.
Remember, this is just the first month release. Let's see what happens.
I know, but
let's see what happens next month. But the
it's
reality,
taken them 24 months to approve. In some cases, still aren't approved. That's what worries me.
Yeah, I agree.
Yeah.
All right, so 701, let's take one more.
Okie dokes. A name I recognize, one I've seen before.
All right. I was on H-1B. We entered the United States on the EAD Advanced Parole card. I-94 was issued for 1 year, even though Advanced Parole card is valid for 2 years. Should I do anything when I-94 expiry date approaches? No.
Yeah,
It's confusing.
I know.
Very confusing, but you remain on Advanced Parole until that Advanced Parole is terminated. People at the customs zone, they've always given a timeline, and you shouldn't be worried.
Yeah, by having a pending adjustment of status, you're allowed to stay in the United States during its pendency. Is the bottom line for me.
With that, we conclude today's session. Thank you guys for listening to us, and join us again next week and bring your questions.